Committee meeting to order. Got a special guest today. My counterpart, mentor in the House, Mr. Chairman. You want to say a word or two to our committee?
It's just such a pleasure to be here, and I want all y'all to remember, if y'all ever come over to the House Regulated Industries, you'll be treated appropriately.
And we do regulate tobacco and firearms. You still packing down there? Yeah. And alcohol. So I thought you'd be appropriate to say hey to us.
And if anyone ever asks you what kind of cigars you smoke, always refer back to Herman Talmadge. The best cigars are any given brand.
Glad to have it.
All right, let's give him a hand. Look forward to a collaborative relationship here. It's a lot of worries in this job. All right, we have two bills we'd like to take a look at today. And the first one is Senate Bill 393, and that is Senator Lindsey Tippins. If I got him in the right order, I got them mixed up. All right, we're going to hear 438 first. You,
38 can.
yeah, or you could address the other one too if you're in the mood. I think it's easier for the audience watching at home if you're from the podium, so your microphone will be broadcasting.
Thank you, Mr. Chairman, members of the committee. 438 makes one minor change in the law as it has to do with public procurement. Under existing law on public contract, state law stipulates that there'll be a 10% retainage held on this work through the 50% mark of the job dollar-wise. What this does is change it to 5% throughout the entire job. And the reason for this change, if you think about it, a lot of the construction work that's regulated are under public procurement. They're very front-loaded in cost. And profit margins, a lot of times, there's not even 10% in a job when you finish it. But there's an abnormal high number, disproportionate cost to start a job because you have to mobilize everything. So what this does is free up 5% of the capital that's currently being retained. Bear in mind, under public procurement, you work for whatever the limit is for the estimate for turning the time limit for turning in the estimate, and then it takes probably another 30 days to get it processed and get a check to the contractor. I'm sure the question is going to be asked, so I'll go ahead and ask it to answer it. You know, does this lessen the protection of the owner? I've been in business a long time. I've never done a public contract that I did not, in addition to the retainage provision, I also have to have a payment and performance bond, which guarantees that the work will be done in its entirety and that all the bills associated with the job will be paid for. We have bonds to guarantee that. So this really does not lessen the security of the owner at all. What this does is free up operating capital on the front end of a job that facilitates actually smaller contractors to be able to bid and perform public work. And that's the only change to it, is a change in the timing of the collection of the retainage. It's the same amount of retainage that is retained, except the percentage is different. It runs through the whole job. You know, at the 50% mark, they would be retaining 10% of the job's total value. At the 100% mark, they're retaining 5%. But it's the same amount that's retained. I'll be glad to answer any questions, but that's the bill in its entirety.
I'd like to either ask questions or make sure for clarification on a couple things. As I understand it, this deals only with public contracts where the government is bidding them out.
That is correct. This does not apply to any private contracts whatsoever. Those private contractual matters, those parties can enter into any agreement that they so choose.
So if I wanted to build a home or build a subdivision and I didn't trust my contractor and I wanted a 20% retention or retainage and he agreed to that, I'm free to do it.
Both parties, and anything both parties agree to, you're free to do it. This only pertains to government procurement.
Okay, and am I also clear that it does not apply to the DOT and road projects, or does it apply to those as well?
I think, is there an exclusion in here for DOT? I haven't heard any issue with DOT.
Okay. I have heard we got some people here, if Gooch will show up, that are experienced in that could maybe educate us, but I've been told by some folks that they don't have retainage on those jobs. Their bidding and payment process is different, so I didn't know.
Well, it is different, and their retainage is basically whatever is stated in their contract. But again, if it's a DOT job, you're gonna have a bond, a performance bond and a payment bond, so DOT's covered.
Okay. Any other members have questions for Chairman Tippins? Yeah, you recognize there's Chairman Mullis.
Number 2. Thank you, Senator, for bringing this before us, because I like this, and I think it's heading in the right direction. I actually wish it would be for the private enterprise, too. I think that with all the jobs out there, sometimes that number is a little too big sometimes for getting everything accomplished, but I like the direction of this, so I'm definitely for it. Thank you.
Thank you, Mr. Chairman.
I dig it.
Other questions? Yes, Senator Ginn, you're recognized.
I'm not sure, and I appreciate your efforts, Senator. One of the things I was hoping that we would hear from the GMA and ACCG on I don't know if they're going to speak, but if they have any concerns, said I'd like to know. And if they don't want to speak, that's fine. I just, it's always good to hear from them.
Well, they didn't sign up, but we are welcome anybody else. Come on up to the podium there, Todd.
Good day, Senator Tippins. Todd Edwards with the Association of County Commissioners. We have, like we do with most of these bills, put it out in our newsletters, ask for feedback. We have not at this point received any negative feedback. Should we? I certainly appreciate my good working relationship with Senator Tippins. As this goes through the legislative process, I'll be sure to bring that up with him, but at this point, we're neutral on the bill.
All right. Any questions for Mr. Edwards?
Thank you.
All right, thank you, Todd. Here we go.
Good afternoon, committee. Noah Randis with the Georgia Municipal Association. I'd just like to echo ACCG's comments. We've circulated this out. We've received no feedback, so we are neutral on the legislation.
At the appropriate time, I'd like to make a motion, Mr. Chairman.
We'll let you know when. Any other questions there? All right. Let me see if we got anybody else signed up.
At the appropriate time, I'd like to vote yes.
All right. Let's see, we're a monster being created in front of our very eyes. Okay, I don't see anybody else signed up. Anybody else like to be heard on this bill? Any other committee members have questions for the author or anybody else that Senator Ginn may want to call out? Okay. Now's the appropriate time if anybody has a motion.
Mr. Chairman, I move due pass on Senate Bill 438 LC 364994.
All right, is there a second? All right, got a second by the minority leader. Any discussion on the bill? Anybody got any other comments? Senator Mullis has shared his affirmative support for it. All right. All in favor, raise your hand. All right. And any opposed? All right. It passes unanimously.
Thank you.
Thank you for your good work there, Senator. It must be a non-controversial bill. We'll see what happens across the hall. Our next bill on the calendar today is Senate Bill 393. It's scheduled for hearing only, the Common Carrier Non-Discrimination Act. Unfortunately, Mr. Dolezal has had an unavoidable conflict come up this afternoon, and he has asked me to let him come on Tuesday to fully explain the bill. I have several people, though, that had signed up and some that have traveled from out of state to be heard on this issue. So we're going to go ahead and hear from anybody that has any comments they'd like to make about this. I have Mr. Servando Esparza, am I pronouncing that right? From TechNet. If you will please introduce yourself, tell who you work for, and give your thoughts and views on Senate Bill 393.
Yes, sir. Mr. Chairman and members of the committee, for the record, my name is Servando Esparza. I'm Executive Director for TechNet in the Southeast region. I'm testifying in respectful opposition to Senate Bill 393. TechNet is a national bipartisan network of tech companies that promote the growth of the innovation economy. To go into Senate Bill 393, what this bill does, it creates an incentive for social media companies to not prohibit and remove any objectionable content in order to avoid any lawsuits. So the bill includes a private right of action for removal of content from a social media website, which the bill defines it as a common carrier, which I'll get into in a little bit, but just want to sort of share that this would open up social media website platforms from being sued if a user has some of its content removed and or prohibited from seeing somebody else's content. The bill only allows social media platforms the ability to remove harmful content that is specifically authorized to remove under federal law or unlawful expressions. In the bill, there's some exceptions in there. Two of those I just mentioned. This would prohibit social media platforms from banning some harmful content that is not specifically illegal under federal law or falls under the exceptions in the bill. Some of those include bullying, racism, hate speech, and spam, just to name a few. NetChoice, which is another organization that we work really closely with on these bills, termed it lawful but awful content. And so some of that content does not fall into the exception. So social media websites cannot remove that, and they could still be sued for some of that information, for some of that content being removed. I also want to flag that there's a portion in the bill, section of the bill, it's actually 46(6)(a)(10). There's a declarant in the case, and I should back up. There were bills in Florida and Texas that were very similar to this. Actually, this is slightly reduced from those two bills. In the Florida case, a declarant, when this went to court, named Stop Child Predators, expressed concerns with the provision that looks just like this provision, because that section requires the disclosure because they say, let me back up, the Act's disclosures requirements give child predators a roadmap to escape detection. If they know how algorithms and content moderation work in detail, they will have an easier time preying on vulnerable children. So what that section will do is it requires social media platforms to describe exactly how the algorithm works to remove some content or why it's flagged. What organizations like Stop Child Predators is saying is what this does is just provides a roadmap for someone that's already going to do something illegal, wants to find a way to not be detected, that roadmap. So I want to flag that concern. As I mentioned, similar bills in Florida and Georgia were enjoined by courts. My colleague from NetChoice is going to talk about that. They were the plaintiff in that case. And then in some of those cases, I'll just say that they go into that they violate the First Amendment, but even then, we believe that they would be preempted by the Communications Decency Act. A couple of other points. I mentioned the common carrier piece, and I think my colleague from NetChoice will talk a little bit about this, but in one of the court cases, I believe it's a Texas court case, talks about that by virtue, in a lot of these attempts in these bills, is to say social media websites are common carriers because a lot of people use them. By virtue of a social media platform, how it functions, it moderates content. Otherwise, they would just let everything go on there, including pornography or anything offensive that someone might think. But social media platforms cater to make sure that it's a family-friendly and workplace-friendly websites. Otherwise, it wouldn't be used, and parents wouldn't let kids or workplaces would ban them if they weren't. And so just want to sort of share that those social media platforms, by virtue of just sort of in their business, moderate content. And so in the definition included in the bill of common carriers, it sort of makes it an assumption that they should allow everything to be in there. And it also just will add that there are exceptions in the bill. So even the bill recognizes that social media platforms should have some form of content moderation allowed on their platform. So I'll leave it there and just open up for questions if you have any.
Tell me a little bit about your company again, TechNet. I'm not familiar with that.
Yes, sir. It's an organization. We have about 90 members. It ranges from some social media platforms like Facebook, Snapchat just recently joined. We don't have Twitter. Then we have a bunch of different types of tech companies: Uber, Lyft, Dell, any sort of DoorDash, Grubhub, any of those types of different companies in that space. A lot of the work that we do is on gig economy work, and so we have about 90 members all across kind of the tech space.
Okay. I think that part of the concern isn't, I don't know how to say it other than just say that it's the censorship or canceling certain voices from your, platforms, we'll call them, and maybe directing, a certain philosophical bent. You promote some and then just shut out other voices rather than worrying about pornography or children getting on there or whatever. What's the viewpoint on that, or do you have any way to make certain that voices aren't shut out of a platform just because the owner of it has a certain political bent?
Absolutely, and that's something that's said pretty commonly, right? That's a lot of the justification for these bills. In the cases that the judges even say, will mention a lot of the statements made by the authors of the bill, the governors, or whoever. I would say that social media websites are placed in a very tough spot. You can have other folks from a different party that will say they don't remove enough. They will leave some things that are already objectionable on these platforms. And so I think what they're trying to do is a careful balance. Do they get it right every single time? Absolutely not. And I don't think they're saying that. What they're trying to do is trying to, remove as much objectionable content as possible. That's how I would answer that.
You mentioned a federal act. I didn't
Yes.
catch the name, but what type of regulations apply to Facebook and Snapchat and all these different social media platforms now? I only know of those two states, Texas and Florida. Are there other states that have regulated the content or the censorship on these platforms?
Not in this form.
How about federally? What's the federal
The
bill?
federal law I mentioned is the Communications Decency Act. There's a section that's pretty famous. Section 230 is described a lot about that. That is what provides some liability protections for content that the platforms themselves do not post, but an individual post. That liability protection extends to a number of internet websites. Just imagine Yelp. Not being liable for an individual giving a bad review and the restaurant not being happy. There's a lawsuit there. Yelp is just a facilitator of that sort of conversation, but they're not liable. That Section 230 provides that liability protection.
Okay. Other committee members have questions? Mr. Esparza, okay. Senator Kennedy, you're recognized.
Thank you, Mr. Chairman. Thank you for being here with us. Following up on the chairman's line of questioning, you talked about the standards that different companies have to determine what's allowed to go on the platform. Where would we look, or where would the public look, but for purposes of this hearing, where would we look to see what document or other sources of information provide the guidelines and standards for what can and cannot be placed on the platform, and alternatively, what should and is to be removed by the owner of the platform?
Absolutely. I think all of the websites provide some sort of community guidelines is a lot of times what they're discussed, and then several of them provide some sort of review, providing some numbers on some of the number of either spam or objectionable content that they've removed. I will say that a lot of that evolves constantly. The best example that I've heard was, as you remember, a couple years ago, there was this Tide Pod challenge, right, where there was individuals eating Tide Pods. That's not something that the social media platforms envisioned. Let's make sure that this is explicitly banned from our platforms. they saw the sort of the damage that was happening and the popularity of these types of posts, and decided this is content that is not allowed, no longer allowed on their platform. So it's ever evolving, but they do publish those community guidelines on their websites.
One more, Mr. Chairman. And and that's a good example. I think the Tide Pods, that's one that we all would agree. But let's drift over here and maybe talk about the political spectrum a little bit. For those situations where content is removed or access is disallowed because of something that's related to what we would all agree is some political statement, political theory, political thought. Mm-hmm. Help me understand who in your organizations, your 90-member organizations, what type of person ultimately makes that call that we're going to take that in content down, or we're going to disallow that person from having further access? Do they have a corporate C-suite name? Is it a board decision? Does it escalate up to the board of directors? How does that work?
I would say that it varies by company, and I think they've all been trying to figure out how to minimize those issues that you talked about, right? How can we avoid the accusation that we're targeting a specific group or not? I think, they've been pretty public that a lot of different companies have, tried to have established boards that are sort of separate of those entities. I think Facebook has something sort of similar. I'm not very well aware of that. Just know that there is sort of like an advisory board that provides some guidance on that. But ultimately, it sort of varies by the companies. I think they continue to try to refine that to avoid those situations.
Thank you, Mr. Chairman.
Any other questions? Senator Harbison.
Thank you, Mr. Chairman. Appreciate it. Just asking questions in regards to how businesses operate. For instance, even cities or communities, each community would have the ability, or in law or just in a common sense, to maintain community standards. Is that true? And quality standards, the quality of care is also implemented in private enterprise as well, to make sure that that particular product or that logo, it maintains a certain standard that it goes by. Would this be in the same vein of trying to do that, making sure your point of view, making sure that you maintain that standard?
Yes, but if I can expand on that comparison, is a city, county, or government, it cannot infringe on someone's First Amendment right.
Sure.
In this case, these are private businesses who have their own First Amendment, rights. And I'm stepping on what Chris from NetChoice is going to talk about, but the court cases talk about this is a violation. These types of bills are a violation of this company's First Amendment right, because it requires them to say things, to publish speech that they would not normally publish, and that would be the difference there.
But in the community, the old saying about someone having the ability to yell fire in a theater or something like that, that would be something similar.
The speech that's not protected.
Yeah.
Yep.
Thank you.
Back to that First Amendment rights, that's, I think, part of the motivation behind these type of bills is that the users of these platforms feel like their right to free speech is being infringed by the platforms who have this monopoly power because of the ubiquitous nature of those platforms. I mean, that some of them have grown so large and dominant that if you want to be heard, you better be able to get on Facebook. And if you say something that the censors at Facebook don't like, then you get silenced, and your First Amendment rights of expression are denied by a private party that is enjoying monopoly power. I've never really heard the angle that you guys have First Amendment. I mean, you're not publishing anything yourself, are you? You're just letting users use your platform? Well, that doesn't mean you're promoting those ideas, or does it?
Well, I'm again stepping on Chris's toes. The court case in Texas does talk about that this is a form of editorial. I'm missing the word. editorial discretion. Like it is a right of theirs. It is a private business. It would be different if, let's say, the state of Georgia had its own social media platform. That's a government entity that could not infringe on someone's individual personal First Amendment rights. This is a business, and I'm sounding sort of cold about it. I don't want to sound cold about the situation you're talking about, because there are individuals that feel like it is unfair for them. But I think what I'm focused on is why this bill doesn't achieve that. So let me just sort of clarify that. It is what this bill does. It would, one, not pass that muster of it infringes on a private business's First Amendment right.
Okay. Other questions? Thank you for traveling. Where'd you come from today?
Austin, Texas, sir.
All right. Nice to have you.
Thanks for having me.
Well, I do have a question here from Senator Albers.
Thank you. Sorry for the last minute addition, Mr. Chairman. Thank you for your input today. I guess my question is, I think you can go back and forth on, I agree on a private company doing what they think is right, even if it is blatant censorship. However, my colleague and I were just talking about, many of you are also publicly traded, and many of you also have contracts with different levels of government. My question to you is, don't you think there's a moral responsibility to not be picking winners and losers here and calling balls and strikes as they should be, not as someone's political wind shift?
As someone that represents several social media platforms, I think it is in what they're trying to do is trying to get better at it, right? Like the number of content that is published on these platforms is in the billions. That's why they rely a lot on the algorithms. What they're trying to perfect is those situations where they get accused of censorship, and I think they're making strides in that. And so I would answer your question in that they're making improvements. I don't, like.
Certainly. One more final question, if I could, Mr. Chairman. Isn't it true, though, there have been several whistleblowers that have come forward, former data scientists that helped build the AI specifically to egregiously push one party's narrative and to silence the other ones? Isn't that true, that they've actually testified?
I'm not aware of that. I focus on state work and what happens in D.C. I just know from the Communications Decency Act portion of it, but I'm not aware of that.
I'll be happy to share that information with you after this meeting.
Senator.
Thank you.
Thank you.
Right. Thank you for being with us today. Mr. Chris Marchese, am I pronouncing that right? Marchese. All right, come on up.
Mr. Chairman, members of the committee, thank you for the opportunity to testify today. My name is Chris Marchese, and I serve as counsel for NetChoice. We are a national trade association of tech businesses. We are headquartered in Washington, D.C., and our members include all the usual suspects like Apple, Amazon, Facebook, Google, as well as medium and smaller size platforms like eBay, Etsy, and Pinterest. So like my colleague Servando was saying, I'm here mostly to talk about the First Amendment and other constitutional problems. But before I get to that, I just wanted to respond to Senator Albers' questions because I thought that they were very interesting. In terms of picking winners and losers, I think that's actually something that we need to be concerned with this legislation, right? So there's a threshold in here that says it only applies to social media businesses of 20 million active users. That's a lot of platforms, but it's also excluding a ton of platforms. So it's also kind of an arbitrary number, right? How do you come to 20 million? So I think that is a signal of picking winners and losers, but I'll set that aside. And then I think another thing, and hear me out before you laugh at it, but I think the winners of social media, believe it or not, are conservatives. I say this as a conservative. I say this as a registered Republican. I say this as somebody who loves free speech, who fights for the First Amendment, who in college got in trouble for fighting for the First Amendment. Conservatives really do win on social media. And the reason for that is because for decades, conservatives didn't necessarily get a fair shot in the mainstream media. The New York Times doesn't really give us fair coverage. But social media, you can develop a direct relationship with your voters and with the public. Former President Trump did that extraordinarily well. In fact, his campaign manager said he won in 2016 because of social media.
But then he got kicked off of Facebook and Twitter, right?
He did. Because, Mr. Chairman, the president, although he is an incredibly important person, is not above the same rules that the rest of us have to abide by. Now, was it the right decision for the platforms to make? I honestly don't know. Would I have done it? Probably not, because I buy into the idea that more speech is better speech. But what I do know is that under the First Amendment, that decision lied with the platforms, and it has to be their ability to decide who their users are. Because if the government can allow force private businesses to host the speech of any user who wants to put his speech out there in the universe, I mean, that's one step away from what we would see in perhaps Europe, China, other countries that don't have a First Amendment or, respect for civil liberties. Now, like I said, I understand that you might be reluctant to agree with me that conservatives do well on social media, but I do want to raise a few statistics. If you look at the posts that do well on Facebook, the top 10 posts week after week after week, it's almost always conservative voices. Yeah, NPR is on there. I don't know if they're considered liberal or not, but I think they're definitely not conservative. So, but otherwise, Facebook, it's conservative messages, conservative media outlets, and conservative voices. On Twitter, same thing. YouTube, same thing. So that's not to say there isn't a problem. I think that there are genuine instances where our members have had to make a split-second judgment and they got it wrong. But like Servando was saying, there are times when things come up online that you have to react to instantly. Like, who would have guessed that teenagers would one day ingest Tide Pods, let alone film videos and challenge their friends to also eat Tide Pod? It's just a weird thing. But switching gears from that to the bill's constitutional problems, I want to focus on the First Amendment. Like Servando said, this bill is almost identical to the one in Texas. And NetChoice actually sued the state of Texas and won an injunction against Texas's version of this bill. Same thing in Florida as well. Something to note, Florida is in the 11th Circuit, as is Georgia, and we expect that our case, when it ends up before the 11th Circuit, we will win. So that would have a direct impact on this bill, but that's still a few months away. So,
what were the grounds for that? What was the legal rationale for that injunction?
Sure. So the court found that more likely than not, we will succeed on our First Amendment challenge, that our members have a First Amendment right to exercise editorial discretion in deciding how to curate and moderate content that is hosted on their websites. And because they have that First Amendment right, the state of Florida's bill was unconstitutional because it infringed on that by, in large part, forcing our members to host content that they otherwise would remove, which is exactly what this bill does. Another problem with it was that it discriminated between speakers. So the First Amendment has a equal protection element where it says the government is not allowed to prefer one speaker over another. You have to treat people equally. In Florida, well, they carved out Disney, even though Disney was it was applicable under the normal definitions in the bill. There was a special carve out to make sure that Disney and all of its video streaming products would be exempted. So the court looked at that and said, that's very suspicious that you're gonna allow one company to exercise First Amendment rights, but not the others. Now, obviously this bill doesn't have a Disney exemption, and I'm glad it doesn't. But what it does have is other First Amendment problems. The first and the biggest, I think, is that it compels speech. The government cannot force private parties to carry speech that they otherwise would not carry. Miami Herald, a 1973 Supreme Court case, found that if you exercise editorial discretion, the government cannot compel you to carry somebody else's speech. So what's interesting about this bill is that it tries to get around that problem by labeling our members common carriers. Now, I have to be honest, I don't think that's going to be a successful legal argument. In Texas tried it and failed. Florida tried it and failed. The rationale being, they're not common carriers. Common carriers are railroads, the telephone companies. Anything that carries a product from one end to another without discriminating on the basis of what that product is or so forth. So a railroad, for example, accepts all passengers. As long as you follow the rules on board, you get to go from point A to point B. A telephone call is from point A to point B. The same is not true of social media. I mean, Google, Facebook, all of them. use editorial discretion to create an environment that users want to be on, to ensure that they are seeing wholesome content and not being bombarded with porn or other graphic images. In fact, the bill itself recognizes that our members exercise their First Amendment rights, because the second half of it, where it talks about transparency requirements, recognizes all the different things that they do. It requires that they disclose how they curate content, how they moderate content, what they do when that content is appealed. All of those requirements in the transparency reports indicate that our members exercise First Amendment rights. They are active participants in their own websites. They're not passive conduits. So because the bill itself recognizes that they do these activities, it's kind of a stretch to then turn around and claim that they're common carriers that don't have anything to do with the actual content itself, that they just allow anybody to put it up there and, you know, they don't even look at it. That's not true.
I'm gonna let him finish his comments first.
Go ahead, Senator, please.
All right.
Or sorry, Mr. Chairman.
Recognize Senator Albers for a question.
Thank you, Mr. Chairman, and I appreciate your comments, and I know these are not necessarily directed towards you individually. Have you seen the movie, The Social Dilemma?
I have.
And what do you, I'm curious as to your perspective on what was learned through that process.
Sure. So The Social Dilemma, I think, raises a lot of interesting questions about our relationship with technology, but I also think that it is playing to our worst fears, and that it doubles down on rumors and, you know, things that we think might be happening behind the scenes but actually aren't. Or maybe they are and there's just no proof of that yet. But when I watched that movie, I thought it was so over the top that it actually ended up kind of overriding some of the more legitimate things that we should be thinking about with technology, such as privacy. So earlier, the chairman asked what federal laws regulate Facebook and Google and so forth. And the answer is we would love to see a federal privacy law. And I think that that would get to a lot of the things that came up in that documentary. But unfortunately, Congress hasn't acted yet.
Can I just have a couple more questions, if I could? Let's follow up on that. One of the great experiments in that movie was someone types into a Google search line, climate change is, and a series of question or answers are pre-populated. Would you like to know that I actually conducted that exact experiment with a friend of mine who lives in New York, who's a little left-leaning, and I'm a little right-leaning. And when I Googled that exact thing at the exact time on the exact browser as he did, I got climate change is a hoax, the greatest threat to humanity, hurts business, etc. at the exact same time. He got the greatest threat to civilization, killing people, killing animals, going to destroy the earth.
So
This is not a hypothetical. This is an actual that is happening right as we speak today. And I understand your perspective, but these aren't maybes. These are actuals that are happening every day, and the concern is grave. And I will share with you, I got canceled 11 months ago because Twitter allowed a group out of Washington, D.C. that was made of pedophilia and sexual harassers and money launderers to say things about me that were not even true. I asked them to take it down, and they refused. And then 7 days later, after I lost my job, they said, oh, you were right, we're sorry, we'll take it down. So this stuff is happening in real time. It is wrong, and it has to be addressed, and there is a legal obligation and a moral obligation to do something about it. And just saying, no, we're going to try and push this off one way or the other is not the answer. The people deserve better.
Senator.
Question?
Yes.
What's the?
Don't you agree?
We got another one going to night law school on us here.
Senator, I just want to say I'm very sorry to hear about your experience, or that you were canceled, or that it had ramifications on your job. That is awful. And actually, cancel culture is something that worries me a ton. So the fact that you're sitting here today, able to tell a story firsthand, just signals that that is a problem. But something that I want to correct is it's not Twitter that allowed you to be defamed. It was the First Amendment. And I think that that's a really important distinction in American law, that there is so much speech out there that we don't agree with and that we want to see removed or that we want to see punished. But thank God for the First Amendment. Thank God that in America, we cannot say to our fellow citizens, hey, I don't like your opinion, so you're going to, you don't get to say it at all. Now, I do realize that there's an irony in that, right? Content moderation is an act of removing certain forms of content deemed objectionable. So I recognize that free speech, only goes so far when it comes to businesses. And that's something that I think is also very important here. When you look at platforms like Facebook, they are free for users. And the reason why they're free is because Facebook's revenue comes from advertisements that are on the website for users to view. Advertisers, it turns out, don't want their ads running alongside conspiracy theories, death threats, or other forms of objectionable content. Tide probably didn't like the fact that its advertisements were popping up on YouTube videos of people ingesting Tide Pods. It's a natural thing that advertisers want their product to be in the best light possible. And because that is actually a user of Facebook, right? Facebook has to consider those things as well. And it's an ecosystem that requires balance. I mean, we could start paying a subscription fee to use Facebook or YouTube, but that would result in less speech. That would result in less communication online, less dialogue, right? Because only people with the money and the desire to would sign up. So it would end up reducing the amount of free speech. So we do have to consider the practical implications on the business element as well.
Recognize one more. One last question for
All right,
Senator
final
Rogers.
question. So in your mind, again, do you believe it's okay then for a Twitter to take someone's post down who said they believe their kids should be in school versus being held at home, but allow another group to say something that's blatantly false and harm someone's life and career?
Senator, it is precisely because I don't know the right answers to those questions that I think it is entirely appropriate for Twitter to make the decisions for itself. And that under the First Amendment, Twitter has that right. And I think that we are all better off when we get to make our own decisions about the speech that we want to host and the values that we want to communicate publicly.
I disagree. Thank you.
Recognize Senator Kennedy for a question, and you'll be next, Senator Brass.
Thank you. Thank you, Mr. Chairman. You know this topic very well, and thank you for giving the rationale behind the answers to the questions. I think that's very helpful for us. And so I think I understand and follow your First Amendment analysis and the legal analysis that backs it up. That is the cornerstone for what you say is the platform's rights to do what we're talking about.
Mm-hmm.
My question is market share of the platform an element of your analysis that also is relevant to your analysis to conclude whether or not they have that liberty or whether or not it should be impaired?
Sure. So on this question, I will defer to the U.S. Supreme Court, which held in Miami Herald that even if you are a monopoly that is actively using your power to manipulate public opinion, it doesn't matter. You still have a First Amendment right not to be compelled by the government to host speech that you otherwise wouldn't host. That case is from 1973, and it's been added on to time and again, reaffirmed time and again. So market share does not come into play here.
Has that case been cited and used for rationale decisions in this sector? Because 73 I recognize as before when Al Gore invented the internet, right? So.
Yes, Senator. Actually, in our two lawsuits against Florida and Texas, that case played heavily, but it is a famous First Amendment case that tends to pop up whenever the issue at hand is compelled speech.
Okay.
So it's across industries.
Okay. Thank you.
Senator Brass.
Thank you, Mr. Chairman. I agree with Senator Kennedy over here. You're very knowledgeable, and so I'm just trying to get a feel for this bill and really some of the thoughts and behind it. So on lines 23 and 24, it does state that as the Supreme Court of the United States has recognized large social media platforms are the, quote, modern public squares, unquote. Is that an accurate statement, number one? I was trying to do some research on my phone and find that. Was that?
Sure. So this actually comes from a case called Packingham versus, I think it was North Carolina.
Uh-huh.
And I think it was decided like 2 years ago, 3 years ago. And basically, it was a case about whether states can prohibit child predators from having their own social media accounts. And the Supreme Court said, no, that violates the First Amendment. And in the discussion of the First Amendment, Justice Kennedy, who wrote the majority opinion, said that the internet is the modern public square. Now, he did not, there was no legal holding. That was just, superfluous dicta. In fact, Justice Alito, in his dissent, called out Justice Kennedy and said that line is going to end up coming back to haunt us, because even though you meant it to be, flowery, people are going to think it's real. And lo and behold, Justice Alito was correct.
So the Supreme Court ruled that child predators can have social media platforms.
Well, the Supreme Court held that the state cannot prohibit them.
Cannot prohibit them, but yet we can stop the President of the United States from having his social media platform.
Well, a private
Right.
company can decide who the users will be. The government cannot.
So I guess that takes me back to more of a fundamental question. When the First Amendment was written, was it to protect private companies, or was it to protect individuals, or was it to protect everyone? What's your thoughts on that?
Sure. So I think the historical evidence shows that it was primarily meant to protect individuals. But at the same time, the founders understood that when individuals get together, they form an association. And a corporation is a form of an association. But anyway, at the founding, the First Amendment was meant to protect your ability to express speech, but also to have your speech be amplified, to work with others to promote your cause. And I think, it doesn't, the Supreme Court has been pretty clear that corporations are a form of associations, and therefore they have First Amendment rights as well.
Okay. Thank you. I'll say, again, I got more information out of you than I did when I searched, but maybe I'm getting censored on my phone. I don't know.
Are you using Microsoft's Bing?
Any other committee members have questions? Senator Kennedy?
No, I was just.
Any smart little comment?
No, I didn't know if that was an advertisement. No, we're gonna get some revenue off of that.
Thank you for taking the effort to come speak with us today. You're obviously very knowledgeable. I have your contact information. If we need any follow-up, we'll reach out to you.
Thank you, Mr. Chairman, and thank you, members of the committee, for letting me speak today.
I don't have anybody else signed up, but in your folders you will notice a letter from the Georgia Chamber of Commerce, somewhat in opposition, basically more of a please wait till we see what the courts do before we go further with this. I'll ask you to review that over the weekend, if you will. There's also another handout we got in your packet in your folders from the Computer and Communications Industry Association, which is in opposition to the bill. They're not here in person to testify, but I would ask all the committee members, if you would, try to read the materials, read the bill. This will be back on our agenda on Tuesday of next week. I am also anticipating that on Tuesday we will have Senate Bill, let's see the number so I don't get it wrong, 421 and 420. Senator Huffstetler has those two bills and was not able to be here today. So I expect we'll have Senate Bill 420, Senate Bill 421, and again Senate Bill 393 on Tuesday's meeting. On Thursday of next week, I announced last week that we're going to hear a series of bills dealing with horse racing that were pending last year, recommitted to us. I've got 4 different bills, some by Senator Mullis, some by Senator Beach, all on that same subject matter. Senate Bill 212, Senate Bill 30, Senate Resolution 53, and Senate Resolution 131. Senator Billy Hickman from Statesboro has, I don't know what you call it, has somehow persuaded Georgia Southern University to do an economic impact study on horse racing, and he's asked to have those individuals that have produced that study to present it to the committee, and so we'll hear that in the context of those other bills. I continue to hear rumors in the Capitol that the House may be acting on some gambling legislation this year, and I feel like we need to be prepared in case that happens and anything comes over to us. So those will be hearings only next Thursday. I am informed that several of the bills that we're sort of holding that were recommitted to us after they didn't get action last session, their authors have asked them to be held. So we're holding some, and we got new bills dropping every day that are being assigned to us. Mr. Kraus, I see you're here from the Public Service Commission. As you know, this Senate Bill 393 calls for it to be governed, so to speak, or regulated by the Public Service Commission. If anybody from the commission would like to be heard on 393, we have no idea if that's something that would be being thrust upon the commission, or that they're, clamoring, asking for the ability to regulate social media. You may want to let them know that will be on the calendar or our agenda for Tuesday if anybody would like to be heard from PSC. Thank you. All right. With that, we are adjourned.